to exclude the First Karabakh War from the court's view, but 3 points can be made at this stage. First, a campaign of ethnic cleansing is not over and done with the minute the last resident is pushed over the border. It continues when steps are taken to prevent or otherwise frustrate the resident's return, and to import and maintain new residents in their place. It continues as the occupying power makes former cities, towns and villages uninhabitable, or destroys the infrastructure or the cultural buildings and artifacts, or the environmental and natural resources that have sustained the community prior to its expulsion. Ethnic cleansing is not an act, it is a strategy, a policy, a campaign. And in this case, it continued after 1994 and after 1996 and up until recent months. Second, Azerbaijan's claim concerning a violation of the CERD by conducting a campaign of ethnic cleansing no more precludes or extinguishes Azerbaijan's separate claims relating, for example, to the promotion of racial hatred and incitement to violence, or to the failure to provide protection and remedies against racially discriminating acts, than a claim concerning apartheid would extinguish claims concerning individual racially motivated murders. The ethnic cleansing claim stands alongside these other claims in this case. Third, it is indisputable that these other claims, such as deprivation of property, incitement of racial hatred, and the prevention of the return of displaced Azerbaijanis to the Karabakh region, continued for many years after 1994 or 1996, throughout the Armenian occupation and even beyond. And this is the key point. Whatever questions Armenia may raise around the margins, Azerbaijan's case is essentially about the fact that Armenia has been violating its CERD obligations on a continuing basis throughout the past 30 years or so. Armenia presented arguments as to what could and could not be part of a composite breach in this case. But it had very little to say about Azerbaijan's main point on jurisdiction, which relates to continuing breaches, and the fact that the breaches in this case continued long after even Armenia's preferred critical date of 1996. A detailed consideration of which specific aggregations of facts constitute composite breaches in the present case is a matter for the merits phase. So is the question of which specific conduct constitutes a continuing breach of the CERD. But what is important at this stage is that there is neither a basis nor even a request from Armenia for a ruling that composite and continuing claims extending beyond 1996 are outside the court's jurisdiction or inadmissible. Mr. Martin spent most of his time on Wednesday on his erga omnes argument, though it's of relatively minor importance to Azerbaijan's case because it only affects conduct completed between July 1993 and September 1996 and leaves continuing acts, including composite acts, unaffected. There is nonetheless a real legal question here. Armenia says that a state party, Azerbaijan, can only pursue a dispute settlement procedure in respect of conduct occurring after the CERD enters into force for it, regardless of how much earlier the respondent state was bound by the convention. Azerbaijan says that once the SERD enters into force for a state, one, it can pursue the procedure in respect of any question concerning the interpretation or application of the Convention, regardless of when the underlying conduct occurred, but two, no state party can be held in breach of the SERD for any conduct completed before the Convention entered into force for that party. It's a narrow and peripheral question which has no bearing on Azerbaijan's ethnic cleansing claim and could only affect any isolated acts that were completed between July 1993 and September 1996, but it is at least a real question. You've heard the parties' submissions on the matter. Azerbaijan maintains that its understanding of the position fits with the ordinary meaning of the words of Article 22. And we note that even on Wednesday, Armenia didn't argue that the application of the rules on treaty interpretation in Article 31 of the Vienna Convention leads to any different conclusion. Armenia simply asserts that the drafters of the SERD could not have intended to establish a position contrary to that now advanced by Armenia, in which Azerbaijan cannot point to breaches of the SERD by Armenia between the dates of Armenia's ratification in 1993 and Azerbaijan's ratification in 1996. Though Armenia sees things differently, Azerbaijan sees nothing unfair or irrational or let alone absurd in a state that has accepted legal obligations being thenceforth expected to comply with them. And I should note two further points. First, in its application, Azerbaijan does not ask the court to say that Armenia breached Azerbaijan's rights, but rather that Armenia breached its obligations under the SERD, and the distinction is important. Second, Armenia seems to view the SERD as a network of bilateral contractual package deals between these states' parties. This is at odds with the plain language of SERD, whose obligations to eliminate racial discrimination are not expressed as or limited to inter partes obligations, but rather, as its preamble repeatedly emphasises, apply to all human beings with a view to eliminating racial discrimination throughout the world in all its forms. And as we recalled on Tuesday, the court itself explained many years ago that in conventions of this kind, one cannot speak of individual advantages or disadvantages to states, or of the maintenance of a perfect contractual balance between rights and duties. Armenia surely cannot seriously suggest that its obligation to eliminate racial discrimination as from 23rd July 1993 applied only to the select nationals of those state parties who were also bound by the Convention as at that date. For example, looking at Armenia's table of SERD ratifications, that Armenia remained free to discriminate against South Africans but not Ethiopians, or against Americans but not French nationals, or against Japanese but not Chinese nationals. More fundamentally, the SERD is not all about us. Conventions such as the SERD are not only about states. They're designed for the protection of individuals. That is their purpose. And that is why the human rights instruments have, and emphasise the importance of having, collective enforcement mechanisms. Mr. Martin also referred to a 2005 resolution of the Institut de Droit International. Interesting as the work of the Institute always is, there are many loose threads here. For example, Article 2 refers to states to which the obligation is owed, not states to which the obligation was owed at the time of the act complained of. And Article 6 says that this is all without prejudice to the rights and remedies pertaining to a state which is specially affected by the breach of an obligation erga omnes, as Azerbaijan is obviously specially affected here. But because this argument is of such marginal importance and the Institute text seems to have left no discernible footprint on the sands of state practice, Azerbaijan leaves the matter there and invites the court to decide this question on the basis of the parties' respective submissions, insofar as it considers that it needs to decide it at all. That brings my submission on behalf of Azerbaijan to an end. I thank the court for its attention and ask that you call Professor Talman to the lectern.
I thank Mr. von Loo for his statement. I now invite Mr. Stefan Talman to take the floor. You have the floor, sir.
Monsieur le Président, Madam Vice President, distinguished members of the Court. My task is once again to respond to Armenia's admissibility objection. The parties agree that a delay, if any, is only relevant if it is detrimental to the respondent. And it is only detrimental if the respondent could have a reasonable expectation that a claim would no longer be pursued. Armenia claims that it had a reasonable expectation that no claim would be brought by Azerbaijan with regard to Armenia's campaign of ethnic cleansing that allegedly took place only before 15 September 1996. I would invite you, members of the Court, to pause for a moment, take a step back, and ask yourself this question. How can a state forcibly seize a fifth of the territory of another state, kill some 23,000 of its nationals, cause some 3,900 of its nationals to go missing, ethnically cleanse a whole area, drive 1 million people from their homes, deprive them of their property, destroy their cultural heritage, loot their natural resources, and then stand up and claim with a straight face that it has a reasonable expectation that no claim would be brought against it. It cannot. But that is exactly what Armenia has been doing the last few days. Armenia bases its purported reasonable expectation on the fact that the latest letter to the UN, referred in the transcript of my speech on Tuesday, dates from the 25th of August 1997. However, these letters to the UN were only given as examples to show that from the 23rd of July 1993, when Armenia became a party to CERT, Azerbaijan had registered its grievances about Armenia's ethnic cleansing campaign with the United Nations and asked for these grievances to be made known to the international community, including Armenia. Numerous other letters could be provided. If one searches the UN official document system for the terms Armenia, ethnic cleansing and Karabakh, Some 224 documents are shown for the period between July 1993 and September 2021. For example, in January 1999, Azerbaijan wrote to the Human Rights Commission that, I quote, "As a result of the policy of the Republic of Armenia of aggression and ethnic cleansing against Azerbaijan, the rights and freedoms of 1 million Azerbaijanis continue to be gravely violated on a daily basis." In 2005, Azerbaijan intervened in the case of Chiragov and others versus Armenia before the European Court of Human Rights, submitting that there were continuing violations by Armenia of inter alia the prohibition on discrimination. Azerbaijan based the violation on the fact that Azerbaijani internally displaced persons were physically prevented from returning home through the deployment of Armenian military forces and landmines on the line of contact. And in 2007 and 2012, Azerbaijan submitted extensive reports to the United Nations on the international legal rights of the Azerbaijani internally displaced persons and the Republic of Armenia's responsibility. Armenia dismisses the letters and documents sent to the UN because they allegedly refer to ethnic cleansing which took place and was allegedly completed in 1994.